May I please, Your Lordship? Your Lordship, I seek your small indulgence.
Huh?
Your Lordship, I seek your small indulgence to kindly allow me to file a mention memo for tomorrow's date, Your Lordship.
Admission.
Yes, Your Lordship. Yesterday, on Tuesday, I filed my writ petition with regards to a transfer petition, but I was informed yesterday that the same could not be listed this week, Your Lordship, since a caveat has been filed.
Transfer order.
Yes, Your Lordship.
Already one matter was filed that was withdrawn, the same matter.
Yes, Your Lordship.
Yes. Come on. Already filed or going to file?
We have already filed on Tuesday, Your Lordship. We have like from the daily list, item number 1.
Lordship,
These are gold biscuits.
yes.
Yes.
Lordship. Lordship, I pray for some more time, Lordship, to file our affidavit.
At the request of the petitioner. Post the matter on so date. Yes.
Much obliged, my Lordship.
The grievance of the petitioner is fully satisfied, my lord. His
Item two.
prayer was item 2, my lord.
Yes.
Grievance of the petitioner was to set up the provident fund account in centralized bank, state bank, and that has already been done, my lord. If the lordship will see this, this is a matter which has been referred back, remanded back to this honorable court.
1 minute, Mr. Amit. Amit, 1 minute.
I'm sorry. Yes, sir.
Okay. Oh, this is with regard to the Provident Fund for the teachers.
Yes,
EPF fund, my
Yes,
lord.
my lord.
There
Yes.
was one matter relating to the EPF fund, the Employees Provident Fund, where the CPF was not applicable. This matter is regarding the CPF fund.
Ah,
Now, they have filed a compliance report. Now, if Lordship would kindly have their affidavit at page 9, my lord. The orders that were passed
1 minute.
by this
Affidavit dated?
this affidavit was filed on 8/4/2024. That is the last affidavit filed by
1
the
minute.
state
8/4.
through my lord.
424. 1
My
minute.
lord.
774.
By one Sri Debu Lindo.
Yes, compliance. Yes.
My lord. Now, Lordship would kindly have page 6 of the affidavit where the order starts. Order dated 5/2/2024.
Page?
Page 6 of the affidavit, my lord.
This affidavit.
This affidavit, my lord,
Page.
where they have annexed the order of this honorable court.
Yes, yes.
My lord. Lordship would have page 9, para 8. This was an order dated 5/2/2024.
Para 9?
Para 8, page 9.
Yes.
Under the circumstances, this court hereby directs the state government or the board of trustees or any other appropriate authority to immediately embark on the exercise to create the centralized provident fund in any nationalized bank by executing the required MOU and thereafter for the said account to be made operational. This exercise is to be completed within a period of 2 months from the date of the order. This was ordered on 5/2/2024. This compliance report which comes on record now, Lordship would find at page 2, para 3, where they say the compliance is there. Page 2, para 3 of the same affidavit, their statement.
Same affidavit.
Same affidavit, my lord. They say the compliance has been there at page 2, para 3.
Scheduled bank, nationalized bank.
My lord, what they have done is the draft MOU on investment between the State Bank of India, Mutual Fund and Board of Trustees will be prepared by this.
Where are you reading, sir?
Page 2 of that same affidavit at para 3, my lord.
Their affidavit.
Their affidavit, it's a
Page
same
8,
affidavit.
yes.
Para 3, I am reading, my lord. It is submitted that in view of the directions set out in the order dated 5/2/24 in the above mentioned subject, the answering respondent is bringing on record the latest status report wherein it is stated that The draft MOU on investment between State Bank of India Mutual Fund and Board of Trustees will be prepared by the State Bank of India Mutual Fund, which will be approved by the Board of Trustees before final agreement. Deed of trust has been drafted and the said deed has been submitted to the Office of the Deputy Commissioner, East Khasi Hills, for registration. Personal account number card, which is essential for opening the trust account, shall be obtained by the Board of Trustees upon receipt of the registered trust deed. This is in April. Order was in February. As of today, there is no memorandum of no memorandum of understanding has been executed. The deed has not been registered, and as of today, there is no PAN number and there is no account. And the restrictions given at PAN is not complied with. There is no provision.
One minute, sir. Yes, Mr. Amit.
Yes, my lord. Your lordship, the deed has been registered on 26 April 2024, my lord. My friend's client is aware of that. 26 April 2024. And
26
in the name
April
of the-
2024?
Okay.
Yes, my lord. 26 April 2024. Deed
Oh,
of Board of
November.
Trustees was registered by sub-registrar on 26 April 2024 under the Meghalaya Non-Government School College Central Pension and Provident Fund Trust. That has been done on 26 April 2024. Now, thereafter, my lord, the trustees have applied for PAN card, my lord. That will be issued by the Income Tax Department, my lord. That has already been applied. And the acknowledgement has been received, my lord, and PAN is allotted and card is under printing from Income Tax
But
Department.
where are the details? Details are not available now.
My lord, I will place those details, but what I was submitting, my lord, is their whole grievance. If your lordship will see kindly prayer. What was their prayer, my lord? Now, what survives, because these are the procedural aspects. Let me just finish. These are the
Whatever
procedural
said
aspects.
that, Mr. Amit, whatever said and done, there is an order of this court, wherein my brother was also a party to that. And you agreed to
Yes, my lord.
complete within a period of 2 months. And
Yes, my
that's
lord, we sought if your lordship will see, my friend has paragraph 9 of that. We sought 2 more months time,
Yes.
and we have got it. We have got it registered on 26 April 2024. Now, trust is already registered.
you,
my lord.
you find the details.
I'll file.
Find the
I'll
details so
file the
that he
details.
will be in a position to, so that we can give a quietness to the matter. See, ultimately
Yes, my
what we
lord.
require is a provident fund. It has got to be, account should be there, amount should be there, PAN detail must be there. These are the things.
Yes, my lord.
That is
I'll file the
managed,
details.
and there is no need to keep
I'll
this,
file Yes, my lord.
this
Matter
godload of
pending.
papers.
Yes, my lord.
It is represented by Mr. Amit, Senior Advocate and Additional Advocate General, that the order of this court has been complied with, but due to the procedural aspect, the particulars like PAN number, etc., are yet to be furnished. He would further submit that he will file a detailed report as to what has happened on and after 26 April 2024 before the next date of hearing. Pose the matter.
After 2 weeks, my lord. Kindly submit after 2
Just
weeks.
2 weeks. Pose the matter some date, sir.
May I just make one more prayer, my lord? In the affidavit itself, my lord, at page 14, they had given the minutes of a particular meeting.
Let them comment. Now we are going to pass any fine. We are not going to pass any orders.
No, my lord, what I was praying is that there was a meeting where a scheme was also approved. They would also give the status of that approval by the board. That status also, if they give, of the meeting held 16 June 2023.
He said he will file everything in detail.
Good to my lord. I'm obliged,
If
my
we
lord.
restrict it only to that, then tomorrow they will interpret the order saying that the court has given only restricted to this.
My lord.
No, we said whatever happened, what has transacted and happened after 26 April 2024 will be furnished before this court.
My lord.
That is all.
Yes, my lord.
I'm obliged, my lord.
Yes, my lord.
Item number 3.
Of course, after last week of June or first week of July.
Last week of June, my lord.
Yes.
Obliged, my lord.
Item 3, my lord, is a PIL. Is a PIL regarding service matter, my lord. Now, documents have been furnished, my lord.
What about the disciplinary proceedings?
My lord, it is going on. Certain documents have been sought by the delinquent. All those documents have been furnished. Some of the documents are part of the charge sheet, which
So we can-
delinquent will under 07, my lord. So therefore, now in PIL, nothing survives, my lord. This process will go on, my lord, because it's a service matter, and initially PIL was filed for the purpose that the steps are not being taken against the delinquent. Steps have already been taken.
One minute, Mr.
My lord, let it be pending, my lord. In the meantime, they can file a status
See,
report
you
with
are
regard to the
asking the
inquiry.
Damocles sword to hang on the head.
My lord.
See, the order has been passed, how is the writ petition maintainable in a public interest litigation? Sorry, the petition is maintainable in service matter.
My lord, it's not a service matter, my lord. This is pertains to the illegal procurement of vehicles, my lord, by the police
This is
department.
not disciplinary proceedings.
My lord, after that, my lord,
So
discipline
is it disciplinary proceedings or not?
has been initiated
If
against.
the disciplinary proceedings is a service matter.
My lord, in disciplinary proceedings has been initiated against one of the respondent, my lord. During this proceedings.
He was the sole respondent, my lord, and in fact against him the charge.
You be present. You be present on that. They will pass us. And the matter is taken for hearing. It is represented by Mr. Amit so and so, and Mr. Khan, Additional Advocate General. That document sought for by the delinquent has already been furnished, and that some of the documents have already annexed with the charge sheet, and that the proceedings may take further time, and that there is no need for keeping the PAL pending. Full stop. They further submitted that it's pertaining to service matter and that the writ petition itself is not maintainable. The counsel for the petition would submit that bench, after going through the various aspects, entertain the writ petition for initiation of action against the fifth respondent. Correct?
During these proceedings, my lord,
Against the fifth respondent. Correct.
Madam, the PIL is pertains to the illegal procurement of vehicles, my lord, by the police department. This PIL is pertains
By
my
the
lord.
fifth respondent
Yes,
only, my lord.
against the fifth respondent, and that it is not pertaining to service matter alone, but also with regard to procurement of vehicles
Vehicles by the police department.
by the fifth respondent.
The police department,
Misusing his powers.
my lord.
Misusing his powers. Full stop. To enable the Advocate General to appear in person and address the matter, we are inclined to grant time. The pendency of the PAL shall not be a bar for continuation of disciplinary proceedings, continuation of the department proceedings or proceedings initiated pursuant to orders of this court, which is expected to be conducted once in 5, without adjourning the matter beyond 7 working days at any point of time. What's the matter? Same date, sir.
Wait for me.
Which is against 7th respondent or 5th respondent?
7, my lord. Respondent 7.
So when you have dictated and completed the order, you are keeping quiet. You must tell us the status. You can't expect my brother. My brother is assisting me and I am assisting him. That is different. But you must say that the order is the 7th respondent. As a junior, you must come forward. Anything that's going to be error, it will prolong the issue. Then we'll have to correct it. Then it has got to be listed again. Yes.
Item number 4.
Yes. 302.
Lordship,
Oh, yes, last time we asked you any 84 is there. Remember?
Lordship, I did not follow what has followed.
Section 84
Yes,
of
Lordship.
IPC.
Yes, Lordship. I have checked 84, Lordship.
Ah.
But in my humble submission, Lordship, 84 will not apply in the instant case
That's good. Then it's against you. Then next
because
point.
there is no medical report which shows that he was of unsound mind. And the second,
Your plea is unsound mind.
Lordship, my plea is not of unsound mind. My plea was
You said that something has happened.
he was in his dreams. He was
Dream.
sleeping.
In his dream he was murdered.
Yes, Lordship. And Lordship, after perusal of the, as your Lordship has already recollected.
What is the medical report about this person?
Lordship, the medical report of the accused person is simply on the physical part. It's not, it does not deal with the mental health status, no.
So
Nothing
when
has been
they
examined.
deal with the mental health, so it may attract 84 also.
Lordship, it might, but there is no document to show that before the learned trial court. And Lordship, in my humble submission, there are two things. In this matter, it is a culpable homicide and the person has been convicted under 302, that is for murder. Now, even if we take into consideration Section 304, culpable homicide not amounting to murder, in my humble submission, both these provisions will not apply to the accused person. Because, Lordship, if your Lordship kindly
Part one,
takes
part two.
Section 299, culpable homicide, it defines culpable homicide.
Yes.
Whoever causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death or with the knowledge that he is likely by such act to cause death commits the offence of culpable homicide. Now, Lordship, there are three ingredients. First is intention of causing death. It is missing in the instant matter. Second is intention of causing such bodily injury as is likely to cause death. That is also not there in the instant matter. Third is knowledge that he is likely by such act to cause death. That is also not available. So culpable homicide gets brushed off altogether. 304 will also not apply to the present appellant. The Lordship, I do not deny the fact that a death has occurred and the child has expired. But there is no eyewitness to the particular death. Allegedly, as per the judgment, it says that PW5, the eldest sister of the victim, has seen the appellant, who is the stepfather of the deceased, strangulating the victim. But Lordship, if we see the statement of PW4 and PW5, the statements of the two of them are absolutely contradictory to each other. If I may take your Lordship to their statements.
You ready?
Lordship.
Proceed, yes. We'll read and come. So we'll read and come. Because 2024, we
Lordship.
thought you were going to, we'll also read and come.
Lordship.
We'll hear in the next date of hearing.
Lordship.
Post the matter for hearing. Once so far, I'm hearing next date. It's sometime in the June or July. Last week of June or first week of July. This is what last time I asked, I've noted it.
Yes,
This is
Lordship.
Section 84 attacks.
Lordship.
Because the person, sometimes he walks in the sleep.
Lordship.
Something,
That examination-
With regard to the.
But Lordship, if the answer coming from the defense counsel says no,
No,
84 is not applicable.
then the moment 84 is not applicable, Lordship, there's nothing in this case.
Lordship, this is regarding sleep. So far as unsound mind, I was on the mental health status which has been taken by on the
This is
document.
also a person who is doing some act with a
Lordship.
dream or something, people may walk at night in the
Lord-
sleep.
Yes,
These are all things with regard to the mind.
Yes, Lordship.
Not with regard to physical
Lordship.
thing. Physical body it also goes,
Lordship.
but depending upon the mind.
Lordship.
So naturally, there has got to be tested. If you say no,
I'll do
That is
further
why
research.
repeatedly we were asking you the question.
I will do further research on this aspect, even if there is no medical report indicating the mental health status of the appellant. Then in such situation, what legal remedy is available?
See, there is a thin line
Lordship.
between schizophrenia and a normal person.
Yes, Lordship.
Suppose you are emotional and started shouting, you will be crossing the borderline. Lakshman Rekha, and you will be called as schizophrenic.
Lordship.
But everything will not fall under that.
Lordship,
Yes,
the law of unsound mind is very, very crystallized. Jurisprudence is very crystallized. Even on sound mind, under 329 of the CRPC, the concerned magistrate will have to see what state the unsound mind was in.
See, he should have taken treatment
Yes.
prior to that.
And then you could stand trial.
Then we can refer.
329 clearly says, but if the stand is not unsound mind, Your Lordship, even unsound mind prosecution has the leeway to say whether he was
See,
capable.
one of the judgment, I think, just sitting with Justice Nagamuthu, I passed an order. The bench, I wrote the judgment,
Lordship.
considering section 84.
Lordship.
But then her stand is he is not taking it.
You see, the 84 I considered in detail, how it is applicable, how it is not. Then he was taking treatment and it was stopped. Thereafter, no continuation. And thereafter, we referred it to the medical board.
That is exactly what 329 does of CRPC, Your Lordship. It refers to the medical board, and the accused still has a liberty. We agree with the medical board, and the court will test whether he is in the mental state
the
based
judgment.
on the medical opinion, Your Lordship. The court will test whether he is fit for trial or not. It doesn't mean he'll have immunity, complete immunity. Medical report, medical board. It's
Only for that
as I said,
particular
Lordship,
period of time.
unsound mind.
I still remember I walked out the judgment.
Lordship.
Lordship, 84 when we set into motion on 329. That itself is a different jurisprudence. Only 84 set into motion 329.
There is one more.
The stand is that it's not unsound mind, Your Lordship. Then we'll confine to 164.
There is one more
That is why
problem in this
initially when you
medical.
started that, it's
She was
not
correct.
84,
She was
84
correct.
is not attracted. Yes.
Absolutely, absolutely.
There is one more problem, Lordship. The medical status report, which is available in the paper book of the appellant, that is also of 2015, whereas the incident had taken place in 2011.
That is different. But he should have taken treatment. He should have taken treatment. There should be some material in order to enable us to see, please examine again whether he is of sound mind or not, whether 84 can be attracted or. You read the judgment and come.
I will read
And
the
you
judgment.
circulate the citation. So I'll also read again.
Lordship.
And Lordship,
Till I write the judgment, I'll remember. Once I write it, I'll forget it. I can't keep, I don't have any 1 TB or 2 TB.
Lordship, the situation would be when he was taking a medical treatment, the court or the magistrate will examine and refer the matter to the medical board. That is the whole procedure. Once that unsound mind is not set into the motion by the defense counsel at the stage of trial, now we at the stage of appellate court. There is nothing in material to record. And her stand is very clear. She is not pleading unsound mind. In fact, she should, because there is nothing on her evidence.
Now she says that she is arguing on 299 and 304. That's all.
That
alone will have to be considered.
That's
And
something
plus,
very
the evidence also, my lord, there are total 9 witnesses. The evidence is absolutely contradictory. Most of the witnesses are hearsay witnesses. There is only one witness who claims herself to be the eyewitness. But when the mother asks why is the child crying, she says that I do not know why is the child crying, despite the fact that she's saying that she's the eyewitness. So this is absolutely contradictory.
PW5 clearly says in chief before the court, she saw the accused strangulating the neck of the child, and there has not been
Contradicted.
not contradicted, not even shaken.
But PW 4 and 5, if we compare, Lordship, there is absolute contradiction. The place where they are sleeping, how they are sleeping, everything is contradictory.
Lordship, let us say Lordship has adjourned the matter.
Yes, we'll see. We'll hear it in first week of July. We'll hear it during the first week of July. We are in May, no?
We are in May, Lordship.
Sometime in June. See, get the judgment, circulate the judgment.
Yes, Lordship.
Circulate the judgment. See, if 84 is not attracted, then we'll have to see
I'll
whether
do further research on that.
anything is to be done or not. That's all. Yes.
From the daily list, item number 1.
May I please, Your Lordship? Your Lordship, due to some personal difficulties, the conducting counsel couldn't come.
What's she saying?
Due to partial difficulty of counsel, she wants time.
For the respondent.
That's problem.
This is with regard to dismissal.
Dismissal. Dismissal and major penalty has been given, gratuity, cancel everything. Even my personal account also freeze.
What are you charging against you, sir?
Charge against me that under the regulation that I have misappropriated some amount amounting to 3 crore something for giving loan. 2 loans I have disbursed. That also under the instruction of the superior officer. I was a branch manager. And the peculiar thing happened, Your Lordship, that during that period when they say the irregularities occur, I got all the excellence certificate. And the inquiry, there are a lot of localness in the inquiry, Your Lordship.
You're an officer.
I'm a branch manager. I've been giving service for 33 years.
You're an officer,
Branch manager?
branch manager. What does the regulation say? Regulation 3 will be there.
Yes.
What is the regulation 3? Should be, you must act with utmost honesty, integrity.
No, the regulation, Meghalaya Rural Bank Officers and Employees Service Regulation 2010.
Oh,
It is there.
I think one regulation is against you. To read that officer's regulation. I don't know about the Meghalaya Rural Bank regulation, but with regard to nationalized bank, the bipartisan settlement, not bipartisan settlement, the regulation is there. And there is one judgment of the Supreme Court is also there. Starts with disciplinary authority. I think 96 or 99, I don't remember exactly.
With regard to some bank, Your Lordship.
Yes, with regard to some
Yes,
bank.
yes.
It's reported in SEC. SEC, I think 99 or where? It starts with disciplinary authority. You have anybody is having a iPad?
I said myself.
Search disciplinary authority. Start with disciplinary authority. If you take the SEC, the judgment starts on the right hand side. The relevant portion against you is on the left hand side, over the page. If any amount is granted over and above the sanction limit, then the amount becomes sticky.
Yes.
Then the officer shall not be granted any relief. That is the judgment of the Supreme Court. So what is your case? Your case is only with regard to whether charges are proved, or you are arguing on the question of punishment.
I argue with regard to inquiry also.
You are attacking the inquiry.
Inquiry is defective, Your Lordship.
On the ground?
On the ground that no hearing has been given to me, natural justice is violated. In the pretext of a preliminary hearing, the report has been submitted. Then I was asked to give the again written statement of defense second.
On the inquiry report.
All that.
Yes.
So therefore, when I give the written statement of defense, when I give them on the grounds, then again they have improved and they have modified, rectified their so-called, Your Lordship. There I was not given a chance to give again for the modification. Then thereafter asked for further inquiry. On the further inquiry, the chairman tried to have a further inquiry. On the further inquiry, again I was asked to give the written statement of defense. When I gave, then thereafter he followed the report without hearing. None, any ground has been mentioned against me.
Do you have the regulation? Have you filed the regulation here?
No, I have a copy, I supply it.
Not filed. Can you circulate the judgment and give it back to you? Anybody has taken out the judgment of the Supreme Court? It starts with disciplinary authority. It reported in SEC 96 or 99, I don't remember exactly, but cost title says disciplinary authority.
88, 89, somewhere, something like that. I think 88, 89, I feel.
No. Sometime in 90s.
90s, no?
I remember the page every.
I don't know, so I'm not last. I shall look into it. Yes. Yeah, there's a violated regulation 18, 19, 22, Your Lordship.
These rules are completely different from that nationalized banks. Yes. At the request of the respondent, who's the matter? Sir, you too. Who's the matter? In the month of June. When will you argue?
On June? In the
Huh?
month of June. Any date?
Any day. Monday.
After 1 week?
You must argue. Don't ask your senior to come. There's an opportunity for you to argue. If you have any doubt, I'll ask your senior to come.
Yes or no?
Sir, how long have you been practicing?
2 years.
2 months.
2 years.
2 years. You must argue with handling. We argue. Yes.
Much worse.
Item number 2.
You are coming from Guwahati or here?
No, I'm here. But
So nobody was able to get the judgment. Nobody is having the app.
I tried searching out, but that was relating to some withholding of some area salary for the period of the suspension. I couldn't go forward further.
Start with disciplinary authority.
The words, it starts with the discipline, I'll try.
The cost title is disciplinary authority, so and so.
Okay, I'll
Yes.
to this matter. But here what had happened is the person was terminated from service, dismissed due to prolonged absence. On the last occasion, Lordship had quoted it. There are 3, my lord.
Mosika, 19 days petition went on to 20 days leave. Appeal refuted the contentious was submitted to the punishment of the compulsory term directive. 90 days, 6 months, given quite as true. What happened?
Lordship, here the petitioner was dismissed from service 6 months short of completion of 20 years, Lordship. Lordship has
If it's
observed,
over and above 6 months, you have to round it off to next 1 year.
Lordship,
It amount to 20 years.
Lordship had observed whether the punishment can be modified into compulsory retirement, Lordship. We are seeking further awaiting instruction, Lordship, in this regard. Sometime may be given, Lordship, and I'm positive that some instruction will come.
The matter is taken up for hearing. The counsel appearing with the respondent would submit that he is awaiting to get instructions with regard to conversion of punishment into one of compulsory retirement. And that the actual period of service rendered by the petitioner is about 19 years and 6 months and actually not completed 20 years of service. It is true if it is rounded off if over and above 6 months is taken, is rounded off, it will be 20 years of service. However, for want of instruction, he is unable to for this court. About the conversion of punishment as suggested with the court on 2/5/2024. The request to give a quietus to the matter and to bring the life of litigation, to bring down the life of litigation, we are inclined to give one more opportunity to the respondent to try about the feasibility of a settlement.
May I just point out one thing that I'll point out? The punishment order was passed after 30 years of his service by giving it a retrospective effect. So that part.
The counsel for the petitioner submitted that the punishment was imposed after 13 years of service.
13.
After 13 years of conclusion of the proceedings.
My lord. And something to help him, my lord, there is one judgment of the Supreme Court which says, in case of a dismissal for absenteeism, a compassionate pension under Rule 41 should be considered by the respondents.
Is a similar rule is available here?
Rule 41, my lord, they have referred to Rule 41 while denying me the pension. I think 24 of the CCS pension rule. Therefore, if they go by the pension rules, they could have resorted to Rule 41 to give me 2/3 of what would have been my actual pension. That is what has been. If I may give him a copy, he can go through it, my lord.
The judgment.
This judgment, my lord, of the Supreme Court.
Circulate.
My lord. It was a similar case where it was dismissed for being absent from duties. Lordship would like to have paragraph.
But here, absent from duty or carrying ganja?
No, my lord, I was on leave. My story is that I was arrested on the ground of carrying ganja, and I was arrested, and they say that I say that I was kidnapped, and I could not come back to duties, and their allegation is that I was carrying ganja. Lordship would like to have paragraph.
It's against that your wife also gave statement.
Yes, yes, Lordship. But the dismissal is only on the ground of absenteeism and not on the basis of my stories. Paragraph 15, Lordship would like to have to see. We shall now venture to apply the aforesaid criterion to the facts and circumstances of the case in hand and decipher therefrom whether the appellant before this court ought to have been granted compassionate allowance under Rule 41 of the Pension Rule 72. The appellant was punished by an order dated 17/5/96 with dismissal from service. Accusation leveled against the petitioner were limited to his unauthorized and willful absence from service with effect from 18/195 to 4/12/95. The above order of punishment also notices that not taking stern action against the appellant would create a bad impression on the new entrants of the police service. The punishing authority, while making a choice of the punishment imposed upon the appellant, also recorded that the appellant's behavior was incorrigible. Thus, there can be no doubt that the order of dismissal from service imposed on the appellant was fully justified. For determining the question of compassionate allowance, so as to bring it within the realm of the parameters laid down in Rule 41 of the Pension Rules 1972, it is first necessary to evaluate whether the wrongdoing alleged against the appellant was of a nature expressed in paragraph 13 of the instant judgment. Having given a thoughtful consideration of the above aspect of the matter, we do not find the delinquency for which the appellant was punished as being one which can be described as an act of moral turpitude, nor can it be concluded that the allegations made against the appellant constitute acts of dishonesty towards his employer. The appellant's behavior was not one which could be expressed in an act designed to
Now the issue is, in this case which you are referring,
My lord.
you consider 41
My lord.
and the employee has rendered 24 years of service.
Yes, my lord. My termination order.
Which he will be entitled to some allowance to the pension and other benefits by converting it to one of compulsory retirement.
My lord, yes.
With less than 20 years, you are not entitled to.
My lord, my termination, if it is taken to be on 30 years of service, because a retrospective termination cannot be there.
We'll see. See, if you are not able to get instruction, we'll pass it. I'll pass orders. Say, converting it to compulsory retirement, taking into account the delay in completion of proceedings, after conclusion of the proceedings.
I'll take instruction.
You take it,
Lordship. Keep it, Lordship.
then pass orders, then you take it to the different bench. That's all.
I hope I'll take instructions before that, Lordship.
Yes.
I'm obliged.
Nothing wrong. See, everybody is entitled to prefer an appeal. Otherwise, this bench will not have any work. Is it not?
We want to give quietus to the matter, Lordship. If we
Give quietness to the matter. See, by this, you will be also be in a win-win situation. You are going to pay him only 2/3,
No, sir.
nothing else.
No, sir. I'll do that, Lordship.
I'm obliged.
You know, even if you don't say also, I am inclined to grant that.
No, sir.
That's all.
No, sir.
There is no purpose in giving full. Strictly speaking, I can't do that because of the delay in completion of proceeding, and more so, you kept quiet for 13 years and allowed him to work.
Yes. I was called back, then dismissed.
I'll take instruction, Lordship.
I'm obliged.
Yes.
I'll do that, Lordship.
Item number 3.
So on, so date. Some date we can give. Item.
Lordship, item number 3, as per the order of this court of second.
Oh, yes.
Lordship, as per the order of 2nd May 2024, I had sought for time because the last paragraph, Lordship, if you see the last paragraph of the order, we stopped at the.
Not present, close the matter on 21/5. Yes.
Lordship. So the last paragraph says we stopped at the issue where the second show cause notice was issued, and then what happened after that. So Lordship, we have just received entire records today morning. So I just need some
Got the
accommodation.
records only this morning.
This morning, Lordship, I need some accommodation. So
Mr. Khan appearing for the AG, Mr. Khan, AG, representing the respondent, would submit that he has received the records this morning, and he'll go through the same and address the argument if there is no feasibility of settlement. Pose the matter on so and so date. See, somewhere or other, one person is taking adjournment. Want to decide as many cases as possible
Lordship, yes.
so that next Chief Justice will have a free time. Yesterday, my PA said I have disposed of both single and bench, 60 matters. So when I came here, the target was 94 division bench. And I got already another 10 matters which are now on the way, already dictation.
Your Lordship, the volume of cases here is very less, at this rate, Your Lordship,
But you can also have free time. You can save petrol. You need not come.
yeah, absolutely.
The national interest, saving petrol.
Lordship, last year we had a difficult time in terms of PILs. 2023 was a year of PILs. We had. So this year at least we are lucky with the PILs have subsided, and then real litigations and adjudications, part of it has taken precedence. Whether it's service matter, whether it's criminal matter.
See, I want see as many pendency is not going to help. More so the criminal matters. One way or the other, they must get the result.
Absolutely, Lordship, absolutely correct. Because if it holds on for 4 years, 5 years,
See, the trial is going on for years,
yes,
and ultimately a person gets convicted. So we may take a different view or we may confirm it.
absolutely.
Supreme Court may also interfere with our order or order of the trial court.
Affirmative, absolutely.
So he may be acquitted fully. So why should he be in incarceration for years? They will get the result at the earliest point of time in the Supreme Court.
Absolutely, Lordship. That's
Suppose we modify the order or we confirm the order. If the Supreme Court can do it. In fact, last week, we passed an order. Last Friday only, we passed an order with regard to the murder committed by a man against another person. His wife escaped. We have reduced the punishment. So we held that morally was responsible. Morally, what he has done is right, but we can't go by moral values.
it has
We
to
have to
be.
consider only the legal values.
Unfortunately, Lordship, Parliament.
Also in murder cases. In other cases, we can understand.
Unfortunately, Lordship, the Parliament has not legislated morality.
Huh?
Parliament has not legislated morality. It's too subjective. So what we have objective law in terms of offences. But Lordship, it's a nice trend that we've been witnessing for the last 2 months. Most of the cases which they should have argued in the trial court regarding reduction of punishment, quantum, provocation. So these were very important aspects.
Yes, I have to see, the problem is
These were not.
313 3:1 in all cases, whether it's POCSO or 302 or any offence, stereotyped one.
Absolutely.
So they are not able to do how to, and with regard to cross-examination also is the problem.
In fact, in most cases, they affirm, Your Lordship. Cross-examination, in most cases, what the witness says in the in-chief, we come and affirm it. That's a very skillful area. Again, we need years of practice and hard work.
Junior must also learn. In fact, I think I gave one instance what Justice Gangapurwala, former Chief Justice of Madras High Court, said. There was a murder. The senior was posing questions to a lady. She was in the witness box and she was wearing a thick glass. So she was asked to stand 30 feet there. She was able to recognize me, she was not able to do. 20 feet, not able to do. And 10 feet, she was not able to do. Then he kept quiet. The Rao Junior, who stood number one in the he said, I want to do the cross-examination. I know something because I'm a first track holder.
Absolutely.
The first question he asked, from when you started wearing the spectacles? Why did you wear this much big glass? He said, I met with an accident about 1 month ago. Completely the case turned against
Absolutely. Everything collapses.
serious, experience, the person would have been acquitted. So here, your practical experience is going to matter.
Like, Lordship, I remember in my young earlier days, I remember the doctor came to the witness box and it was a rape case. I asked the doctor whether rape is a medical term or a legal term. He said it's a medical term. Because he had given me a report finding that this is a case of rape. I asked him whether it's a legal term and he said it's a rape medical term. His whole evidence collapsed.
Sometimes I feel certain things would have happened with provocation, all those things that would happen.
Lordship, that's a very vital part. In fact, like murder cases, those are clinching. There are a number of cases, Lordship has put that question and reduced the sentence only on that.
Suppose you are going to bring a hooligan and do the run away with the person and all, that's an entirely different thing.
Absolutely.
Suppose in a domestic place, suddenly this happens.
The whole case hinges on provocation. And the whole quantum of punishment depends on that provocation.
Sometimes the person will be incarceration for more than 10 years.
Lordship, yes.
So we will say that itself will suffice.
Absolutely.
So
And
we
then
cannot also completely acquit him. If you acquit, then for the incarceration, the state will have to pay compensation.
Exactly.
All those things will
So
be
there has
there.
to be balancing,
Exactly.
80-20 balancing. So that
Do you want to know?
Nowadays, practicing in lower court, in trial court also, it's not
See,
so
the
easy.
rest of the cases, I do agree. But out of the 840, when I came here I took vote on 11th February, the total number of cases pending was 848. Out of 848, 212 were service matters. Were service matters. Then I said, I'll take up some matters. Then I found that I was able to dispose of only 10 or 12 matters because one person or other person is taking adjournment. Now I will be doing some work. After 1 month, I will also, like you go in for a vacation mode, I will also go in for a retirement mode. Anyhow, because I want the juniors to understand. That's very important. Juniors must be encouraged.
in fact, Lordship, they're missing one of the most golden opportunity before this court.
Yes, yes.
They will never experience this again, I'm sure, because all we have previous experience was.
I'm telling you, see, when my two seniors were there, when my senior was there, the court, Justice Shivappa was there. From Karnataka, he was in Chennai. Our case was 4th case. I was in that court. I was prepared. Because I have been told that you must be ready to argue the case. Instructing counsel must be ready to argue the case. It's like a junior surgeon. He must be prepared to do the surgery when senior is absent.
Absolutely.
So I was completely prepared. the case arising out of some disciplinary proceeding from Pondicherry. Remember that. First question here. Immediately, first 3 cases got over within a minute. Our case was called. 10:30 sitting, 10:35 the matter was called. Immediately, I was ready to argue the matter. First question he asked me, where is your senior? So and so, where is your senior? I told him, he may not like to say that he's held up in the single bench or some other court. Actually, he was held up in the first court. I told him he was held up in the first court. He said, where is the other senior? Then he said, he is held up in the other court. Who is going to do this? I'm ready. Will you do it? Can you argue this? Go argue the case before me. Yeah, this was the way you know address usual. I immediately said, my seniors told me that I'll be in the safe hands. So immediately, what is the matter? I told him in 2 sentences and showed him the latest judgment of the Supreme Court that the BC Chaturvedi case came at that point of time, 1995. 3 judges. I told him this is the, with regard to proportionality of punishment, how it can be interfered with. Immediately agreed with me. That's all 5 minutes. Even though hearing the other side, no, the punishment has got to be modified, everything. Abusive language and I think abusive language. And immediately I agreed. My senior, after completing the first case, came. Some junior went and told him that the matter is going on. The judge is posing a lot of questions to him. So unless you go there, it's going to be a problem. By the time he was about to allow my case, he came and said, no, I am ready here. This judgment, that judgment started. He admitted and posted the matter. Then my senior came, and on that day I could not get a favorable order. The matter got admitted, and it got over after 5-6 years. The very same result was there before some other judge.
Those are some defining moments, Your Lordship, when anybody's career. When
sometimes this also happens.
Yes,
Senior must also be there, watch and do what. Similarly, Justice N.V. Balasubramanian was there. And I was arguing a matter. Then my senior came and he was saying something to me. He said, why do you disturb him? He is doing well. Then immediately he said, no, I told him that one more case is there. Just to instruct him, I came here, he went. That is also a reported judgment with regard to addition payments in transfer matter. The Justice N.V. Balasubramanian has reported, delivered judgment after 14 months. It's a reported judgment with regard to transfer. So some judges may encourage, some judges may not encourage.
we have, Lordship, absolutely. All those experiences are there in a career of a lawyer. These are experience that shapes us.
Some judges may not respect, when I was practicing, some judges may not respect the senior, may not respect the junior also.
Absolutely.
Similarly, when Justice Ratnam was there, he was very friendly to the juniors. He will encourage the juniors, but he was very tough to the seniors. He will expect the senior to tell the point, whereas he allow the juniors to say. So let him also be, be comfortable in the court. That kind of judges also we have seen.
And it helps the bar to grow, Lordship. In long run, the juniors, once the confidence comes in the juniors.
Otherwise, what will happen is the person who is come to the court with confidence,
Absolutely.
I become a lawyer, I'm going to argue the case. If you ask so many questions,
He'll never be out.
they'll get disturbed and they'll have the fear of court.
Absolutely.
And they will not be in a position to progress also.
And in the long run,
Ultimately, none of us are permanent here.
absolutely.
The institution alone is permanent.
Absolutely correct.
So when the institution is permanent, juniors must be encouraged. Only then they will be in a position when they become senior, they will encourage the juniors.
Lordship, we have walked the same path. In fact, like 15, 20 years down the line, we had walked the same path.
Good.
Absolutely, Lord.
Anyhow,
Much obliged. Much obliged.
yes, sir.
Judgment the Lordship was referring to, perhaps it is 1996 9 SCC 69 Disciplinary Authority versus Nikunja Bihari Pattanayak.
The judgment. You read the second page, where the amount has become sticky and all is there.
Yes, madam. It is regarding to giving over.
That's amount. The word used is there, and the amount has become sticky is also there. So 96 correct,
96.
This she has also taken. 1 minute. I also said that the judgment starts on the right hand side. Starts on the right hand side. Starts on the left hand side is the judgment. See, the regulation number 3, which is in the bank's Central Bank of India office, such is not available. Every officer shall at all times take all possible steps to ensure and protect the interests of the bank and discharge his duty with utmost integrity, honesty, devotion and diligence, and do nothing which is becoming or unbecoming an officer. This provision is not there in your rules.
In the regulation.
But you got to buy it. See, he also found that in some cases, the bank stood to gain, while in some other cases, the advance concern had become sticky. That's why I said start over the page, it's there.
Your lordship got a wonderful memory.
No. Sometimes no. Now, because I'm not dealing with the service matter, sometimes I'm not able to recognize. Otherwise, used to say, see, even though I used to give all these citation, other things, when my senior argues, he never said that I am up to the mark. You see, what you have done is not sufficient.
Sky is the limit.
Huh?
For growth. Sky is the limit for growth.
Never said that you are perfect, you are correct. But anyhow, because your seniors are teachers, so we have to learn. So they are not going to do any bad thing to us. That's how we have to take it. Yes.